Urge? He said something before.
Yeah.
Yeah, we got you now.
I thought that was George.
That wasn't George? Oh. I was getting ready to start.
George, can we start?
All right. All right, everybody. I'd like to welcome everybody to the July 28th ZBA meeting. I know we've been gone for a while, so I'd like to make up for lost time tonight and get everybody heard. I'd like to start tonight with roll call.
Steve Thao.
Here.
Chip Poglione. Working on it. Zach Murphy.
Here. Thank you.
Kevin Scully.
Here.
And Aaron Hughes.
Here. Pledge of Allegiance. Thank you, everybody. I'd like to point out the fire exits as well. You have two in the back and then two behind me this way. Our first public hearing of the night is going to be from the planning board. Would anyone like to step up and... Okay. How are you?
Yeah, good.
It's been a while.
Yes. Should I sit or?
Sure. Get comfortable.
Yeah. Adam Rod, on behalf of the planning board. Our understanding is when we last appeared in February, which was our second meeting before the board, closed the public hearing, I believe, in February, and didn't ask for any further submissions. There were voluminous submissions on behalf of the planning board and the applicant. And we found out about tonight's meeting, I believe, yesterday, that it would be on the agenda. So I guess as a point of inquiry, to the extent that the public hearing was closed in February, I mean, obviously we're here because we were advised, but
Adam, if I could interrupt you, I have notes here that the public hearing was not closed, and we
Yeah, it wasn't.
continued it at that time until the March 24th ZBA meeting, so it is still open.
okay.
We might have made a motion to close it, and then the lawyer at the time, we talked about it, and I think in that meeting, we also made a motion to keep it open.
Yeah, that was my understanding.
Right.
The video.
Okay.
Speaking to the mic when you...
Oh, I'm sorry. Is that better?
That's good.
Okay, I mean, that's fine. My
Yeah.
recollection was the board did not want any further submissions. I'm happy to answer any additional questions or, to restate our position, whatever.
Well, it's been months since we've heard from either party, so I'd like for both of you to kind of say your piece, remind us what was going on, and,
Sure. Basically, this is an appeal from a determination from the building department dated September 10, 2025. The applicant had two pre-application meetings with the planning board, and during those two pre-application meetings, it was pointed out by the representatives from the planning board that you're presenting us with plans that have, and the plans varied, but basically almost an exact correlation between bus parking spaces and parking spaces for cars. And it was pointed out to the applicant that what you're proposing here is essentially a bus depot or bus storage facility. That is, it was property in which drivers onto the lot, park their cars in the designated parking spots, then pick up their buses, run their routes, return to the lot, park the buses in the designated parking spots where the buses are kept and stored, get back in their cars and drive home, which is a classic bus depot, which is not listed as either a permitted use or a special permit use in the GB district where this property is located. In any event, after the planning board advised the applicant that it did not appear that you're proposing a use that was even permitted in this district, the applicant then went to the building department and asked to request that the use be permitted or to get approval for the use, which they did. Planning board was unaware that the applicant had went to the building department. The building department then indicated that it was a permitted use. And they then returned to the planning board, I believe October 23, if I have my dates correct. And that was the very first time that the planning board knew that they applied to the building department or got approval from the building department. And hence the immediate appeal. I believe November 7, 2025 is when the planning board appealed. And, simply put, the basis of the appeal is what you're proposing is a bus depot, which is not permitted in the zone. It's not a special permit use. I don't believe the applicant, even the two prior public hearings that we had, even disputed the nature of what I just described that the use would be. That is, the most recent site plan, I believe, has 29 bus parking spaces. It has 29 car parking spaces. This is property that's being put to use as a bus depot. And again, the applicant did not dispute the use. I think at the last public hearing, and I might have been the first one or the second one, the comment was from the applicant, well, sometimes the bus drivers would actually take the buses back to their houses. And I know there was some skepticism raised by some board members. But, I mean, even accepting as true that, okay, I don't think it's a particularly plausible explanation. We're talking about, the operator of the property, shouldn't be lost, I believe, is excellent bus service. So, again, the entire basis of the appeal, simply put, is that they're asking to put this property to a use that is disallowed under the town's zoning code.
That covers what we knew from the previous meeting, too.
Was there, yeah, that's pretty much the happy recap from what I remember. There was also a timing issue of when the planning
Filing
board
occurred.
had to put in some paperwork.
Yeah, there was a 30-day filing time
So, yeah, I'm
period.
looking here, the land use determination was dated on September 10th, 2025, and the planning board's notice of appeal is dated on 11/7/25, in excess of the 30 days. Can you go into a little more of that as far as why that was?
Yeah, absolutely.
Just before you do that, so you had to have it in before 30 days, correct? Or is it 30 days or 60 days? There was some question on that time frame that we discussed up here.
It said that there's supposed to be in within 30 days. It took 58 days to get it, based on a disconnect between the planning and the building inspector.
Yeah.
And based upon good cause shown, we may be able to waive the requirement of the
Yes.
30 days.
Yeah, I mean, your code specifically provides for an extension of the 30-day period for good cause shown. And that's exactly the situation that we're talking about here. Not to throw stones, but your particular code does not have a mandatory requirement that says determinations coming from the building department must contemporaneously be filed with the planning board, zoning board, or town board. There's no such requirement. And there was the planning board did not know of the approval until they came back to the planning board on October 23. So we had no reason to know that they either applied to the building department for that use. We weren't copied on it. That's not disputed. And there's no dispute that the building department did not give us the approval, meaning the planning board, at the time it was approved. The planning board first learned about it on October 23, and we immediately filed a notice of appeal on November 7th. And again, your own code, the town of Monroe's zoning code specifically provides that the 30-day period of time may be extended for good cause shown. And that's exactly the case here. There's no dispute that the planning board was never notified of this until October 23. And we immediately filed the notice of appeal.
That sounds like a communication issue with the process as a whole, that the building inspector kind of potentially should have let you guys know that this was approved. Is that kind of the thought process here that you're having?
So I think, from my perspective, we have these informal technical advisory meetings before someone even submits an application. So there, in fact, was no application in front of the planning board or the building department. And so then there was a technical advisory committee meeting. The applicant clearly stated that a bus depot was proposed. And my recollection is we let you know that there's something called bus shelter in the code, and so that the applicant got confused thinking a bus shelter's a bus depot. So after that, absent an actual application, absent anything formal where we would have known that a determination had gone off to the building inspector, the applicant submitted their paperwork to the building inspector. Again, no application, no nothing, just conceptual, and they got this determination. We were not told of it. I will also say that just from some case law, I'm not an attorney, but from some case law, that statute of limitations, there have been cases where that time runs from when you find out. So it's not simply just 30 days. If we don't know, how is 30 days relevant? It's 30 days from when you discover that, in fact, a determination had been made. So, and our own code says that that time period can be extended as well. So legally it can be extended, but again, we're talking about a situation where a determination is made by the building inspector on something that doesn't even have an application. Absent an application, how would anyone know? So again, bus depot, applicant went off to the building department, there was a decision or a determination made, came in front of us again for a technical advisory committee meeting because there's still no application, and informs us that this is the determination the building inspector had made. I will only say from the planning board's perspective, this is not an automotive repair establishment. This is not where someone owns an automotive repair, auto body workshop, etc., where other individuals bring their vehicles to get repaired that are not related to that auto body establishment, that then go off after 3 days or 1 week, however long it takes to fix the car or the vehicle, and then goes and takes their car back to their home. That is not at all what's happening here. This is a place where buses are being stored, period. That's the primary use of this property. And ancillary to that is while they're there, yes, they may get repaired, but that's not the primary purpose. So the planning board disagrees with the determination that was made, again, on something that didn't even have an application and was conceptual. And we believe that it would be appropriate, rather than this use evolving from a building inspector determination, that this is something more appropriately taken up by the town board. If the town board wants to allow a use similar to this one, a bus depot, they can weigh and balance whether it's appropriate for that zoning district. And to us, that would be the prudent, wise thing to do. We don't believe that land use policy should be made through a building inspector's determination, which really stretches the meaning of automotive repair establishment.
So that's the first, I think, I've heard of that. So are you looking for this board to make a determination that this is to be brought in front of the town board?
No, I don't think that that's a determination you
kinda what-
can
It's
make. I think it's just
Well,
simply
isn't that what you
either.
just said? You think that this,
I believe, just as a planner, that what's happening here is that there is a use that's somewhat, the meaning of that use, the definition of that use is being expanded way beyond what it really is. You know, it's being expanded and interpreted in a way to allow a bus depot. I don't think that's appropriate. I'm saying as a planner, I think what's more appropriate would be for the ZBA to deny that determination, and that if the applicant wants to pursue a bus depot, they should separately go to the town board and say, look, I think this is a great use here, it'd be appropriate, we should rezone to allow that use in this particular zoning district so I can do what I would like to do in that location. I don't think the ZBA should, in essence, by broadening the concept of what a automotive repair is, should allow a bus depot there, if that makes sense.
so going back, you know, because everything is all becoming very clear again, and checking with at least my notes. So I'm a big proponent of having those pre-meetings like you had, those, you know, so, and I guess we'll hear from the other side too. We'll give, I guess we'll let them speak, but is it possible at those meetings that you said, hey, a bus depot cannot be here? Did they leave that meeting and adjust and then revise their plans?
No. First of all, our attorney was at that technical advisory committee meeting. It was held electronically, a Zoom kind of call. And she's the one that said, this isn't allowed. A bus depot is not allowed. It was in no uncertain terms, she indicated that.
So just to be clear, the way it was first put forward was for purpose of a bus depot? Okay.
Yes, and that we believe there was confusion, again, because in the code allows as an accessory use a bus shelter. But the bus shelter is those things you stand under. Yeah, bus stop that you stand under that, you know, for weather, inclement weather, et cetera. The applicant then went off to the building inspector to try and fit this bus depot into something called automotive repair to allow it to happen. And it's not an auto repair, it's a bus depot.
Thank you.
Yeah, so I guess that's where we keep running into issues. What is actually allowed on this spot? You're saying it's a bus shelter, and
No.
that's,
No, I'm saying that we believe that the applicant got confused because in the zoning as an accessory use building
Yes.
is something called a bus shelter.
now you're saying a
But
bus
they
depot cannot go there, but a bus shelter could. That's your argument. But this is not a bus shelter
This is
even
not, this is a
remotely.
bus depot.
That's okay, that's your
Yep,
argument.
and they wanted a bus depot.
Okay.
But I think in the language it got confusing, and they must have thought this was allowed under the term bus shelter. Because I recall discussing that on the Zoom call.
But a maintenance facility falls within the zone. Yes, that,
It has to be the primary use. In automobile repair shop is allowed in the GB district, but it has to be the primary use of the lot. The mere fact that you have 29 car parking spaces and 29 bus parking spaces does not transform this into an automotive repair shop simply by reason of the fact that, well, we can repair some of the buses that are stored there. I mean, clearly, the site plan speaks for itself.
Yeah, no,
So if this lot was to be a bus mechanic shop, by your logic, that would be okay. But the fact that the buses are being picked up and dropped off as if it was a depot, in your words, that's not okay.
Right, this is a bus depot.
It's not your run-of-the-mill mechanic shop, that's what you're saying would be
No,
allowed.
and there's never been any representation by the applicant that, this is a place where, hey, you know what, I want to bring my, Honda Civic in for an oil change or an inspection. I'm just a guy that, wants to come to the property. They're not saying that at all. This is, again, being redundant. They have 29 spaces for parking and storage of buses. Company is excellent bus service, and the purpose of the property is for drivers to pick up and drop off the buses after they run their lots. Oh, and by the way, if we have to do something to the buses in terms of repairing it, they're claiming that they can do that on site. I mean, which is fine, and we're not disputing that, but the code is very specific. It has to be the primary use. And again, when they came before the planning board initially, we're proposing a bus depot.
that was an unofficial meeting though, right? That was just, isn't that like, and maybe I'm wrong, isn't that like a fact-finding meeting saying, hey, this is what we'd like to do, and, just bounce off ideas and get a feel for what is allowed, what's not allowed? Is that considered official?
Well, I mean,
It's-
regardless of what it's characterized as, throughout the whole process.
No,
even
I get
before
it, but don't you think every action is a reaction, right? So in that meeting, when they discussed a bus garage or a bus depot, whatever the terminology they used, and it was shot down right then and there, right? Did you're saying by their site plan that no changes were made and there wasn't a reaction to the action of no bus depot?
There was, in terms of the plans that were submitted, there were minor tweaks in terms of the number. I think one of the site plans had like 30 bus storage spaces and, 27 car parking spots. There's never been any change in terms of the thrust and the use of the property throughout the whole process. The most recent site plan, which you have that was presented, has 29 bus spaces, 29 car spaces for use as a bus depot. And the mere fact that, well, by the way, we can service some of the buses while they're stored there and not in use does not change the fact that this is still a bus depot. And again, it's just a straightforward reading of the zoning code. If the town board, and they got very specific about these are permitted uses, these are special permit uses. There's no prohibition ever for them to have decided, again, it's a legislative determination, we want to include bus storage facilities or bus depots. They did not include that. And as indicated in our submissions, it's just a basic tenet of zoning law that when you have very specific listed enumerated uses that are not listed on them are prohibited. And they're not listed, it's a prohibited use, and the applicant is, throughout the process, I don't want to, speak for the applicant, but they're not disputing the essential use of the property, which is to pick up buses, drive the routes, and drop the buses back off overnight where they're stored. Again, the property is being operated by an excellent bus company. It's a bus company use. It's not, by all accounts, any way you look at this, the primary use is not in what we think of as an automobile repair shop.
And,
I
and
don't believe I don't want to be presumptuous, but I mean, have you ever heard of an automotive repair shop that has 30 spaces for cars and then 30 spaces for buses?
and the bottom line is, this is the definition. They're not asking for a maintenance facility. That's what they may have said. That they're trying to fall within the use called automotive service station. An automotive service station is defined as a building or lot or part thereof devoted primarily to fuel dispensing. Automotive service station means like a gas station. Automotive service station primarily for fuel dispensing, repairs, servicing, washing, or reconditioning of motor vehicles. It does not mean having these buses every day for an extended time period, being there on a daily basis, on a regular basis. Automotive service station is fuel dispensing. It's what your typical Sunoco or your typical, gas station used to be in the day when you had that accessory tires and inspections and other things. This code is from 2017. And again, I'd remind the board that I was the one that was responsible for drafting it. So I can tell you that in my opinion and in my experience, and what was intended was not to allow a bus terminal or bus depot under this definition. And again, this isn't about not liking the use or talking about whether it is appropriate in that location. Our objection is that this is not an automotive service station. And if the applicant wants to pursue a bus terminal, there are other more appropriate avenues. You asked me whether this is an official, having these technical advisory committee, processes.
Right.
That is something to help the applicant.
No, I understand what
Yeah.
that is. I just didn't know if you consider that official or not. I understand what a technical review is, but, it's a lesson learned, fact finding. I would think at those kind of meetings, there would be, and this might be silly of me, there would be partnering. There'd be come to an understanding of what's the purpose, what can't you do, can things be modified? But, that's just for me to understand. And
Agreed.
the other thing, and I'll just speak for myself, this is the zoning board is being put in a very difficult situation, right? Because we have another member of the town that's approved this and signed off on it and said everything's hunky-dory, and then we have another aspect of the town, the planning board, putting an appeal on it. It's just a
Messy.
It's a shitty situation, excuse my language.
I guess I don't characterize it that way.
Yeah.
It's a disagreement. And there was information and facts provided to the planning board. That information and facts were reported to the building inspector in a manner different than what was reported to this planning board group. And so frankly, the complication in all of this is that the building inspector would make a determination absent even an application, an actual site plan or a special use or something more than a concept. And that is part of the flaw in all this as well, was that quick reaction to issue a determination. What would have been appropriate would have been for the applicant to come back again and say, okay, we're going to revise this, et cetera. But instead, there was a submission to the building inspector, and no one informed the planning board.
Now, do you think that's a problem, that's potentially could happen over and over again?
Well, so we had a conversation prior to the new administration, and we had said that it would be good if there was some kind of policy that when you have these kinds of determinations, that the planning board should be informed when they happen, because, and that you should consider what the process is for making determinations before there's even an application. So that was communicated, but obviously, you know, there's been a lot going on. So it's just hasn't risen to the top in terms of a priority, as far as I know.
I think it's a fair request.
I think the process could be made better, absolutely.
Yeah.
But
There's been other.
this
This has been issues before, yeah.
There's been other things
many.
in front of us in the last year and a half like this.
Where determinations have been made that have had issues.
Yeah,
Right,
that's,
where we're putting in the middle.
we kind of
So-
have a bigger issue here going on. Like, if this keeps coming back to more and more things,
Yeah. Well, and, you know, if you think about it, every time you issue an area variance, right, someone's appealing a decision made, or they need a variance because they don't fit. And from our perspective, this just doesn't fit. And there's a different path to go to be able to obtain this use. And the town board is the legislative body. They're the ones that should enact land use policy. That's the appropriate route. It shouldn't be done kind of through the building inspector and these kind of determinations. It's important, and let the town board take it up as whether this use would be okay there. There was zone change.
Bonnie, I have a question for you. You said you were involved with the original writing of the zoning laws back in 2017. So I'm looking at this here, district in the GB zone, number 1, under principal permitted use, it states automobile sales with accessory service facilities. Does that mean that the service facilities would be an accessory to an automotive sale business?
Yes, the primary use would be automotive sales.
So in
So
essence, then, without
a
automotive...
car, you know, sales lot.
So the way I'm reading it then is absent automotive sales, then a repair facility is not even permitted.
In that instance, correct.
That's what?
In that instance, correct.
Well, I think
You
in any
can't- you can't-
instance, because that's the
different
principal...
than what you were saying before, where it had to be a maintenance facility first.
Right, so is it the principal permitted use, is it
It's
a maintenance facility, or is it automotive sales with accessory
It's
repair facility?
It's automotive sales, because the repair is only accessory to the automotive sales.
Okay, so
So
that...
absent automotive sales, there's no reason to have the accessory repair.
Because I think what was said before was that the principal use was automotive repairs, but that is not the case when I read this on the GB zoning, principal permitted use. So now we're kind of 3 steps in. We're talking about a bus depot, auto sales with an accessory to the service station.
Which
Correct?
is different than what you were putting forward just 10
Well,
minutes ago.
So I was putting forward simply, it was the applicant that got a determination from the building inspector that this should be classified as an automotive service station.
Right, but without automotive sales, the service station is not even allowed, let alone a bus depot, for that matter.
I believe the automotive service station is allowed by
I would
special
think-
use
I would
permit.
think that there would have to be.
It's special use permit,
Yeah, special.
Special use permit.
yeah.
Not
So-
in principal permitted use.
Under column 4, it's item 5. So their request to the building inspector was to get a determination that this is an automotive service station. But if I read you the definition of automotive service station, the primary intent is actually the first thing that's called out is fuel dispensing.
But then
because
let me
it's-
just take that one step further. Under column 4, then, the special use permit for item 5, automotive service station, says here authorization and site plan approval by planning board, not the building inspector. So if the building inspector put forth an approval, is that a concern that it wasn't approved by the planning board, as it states here?
They were, I don't know if you want to say it.
There's
it's-
got to be,
So it's-
there's got to
they're
be a
not
flaw in those
They're not
codes.
approving, he's not approving it. What he's saying is, We looked at this application and said, and the applicant told us, we want a bus terminal, we want a bus depot. We said, that's not what this is. That's not what's allowed in this zone. They went to the building inspector and said, we think we fit under automotive service station, and this is why. And the building inspector said, yeah, I think you fit under that use.
I get it, and I don't want to put words in anyone's mouth, right? I'm just dealing with the facts, where Steve is reading the code and going by what you just said is you read, like, you used the word, it was meant for like a gas station.
That's the
Right,
definition.
but,
Yes.
yeah, but a gas station is not an they're not selling,
No.
right? So you could see how foggy and vague this is.
Well, yeah, if I can just add it is pretty clear actually, because when you look under the definition of an automotive service station, in terms of like the use, it's the primary use to which the property is put to. And here, clearly under the site.
No, I get that, but what, it has nothing to do with sales, though.
No, but that's a different use altogether.
Right.
So they're not trying to say they're automotive sales as far as I
No,
know.
no,
I know they're not.
They're trying
we're
to
not.
say,
We're just reading.
I'm just reading the principal permitted use
We're
versus
just
the
reading
special
the code
use.
that you said you worked on.
yeah,
Right,
so,
and that's all we're using, and
Correct.
just trying to figure that out. Discrepancy between this and then what you said about a gas station, a service station, and then when Steve read that it had to be sales first with an auxiliary service.
but that's for a different use altogether.
Yes, right. So
So
again,
you
it's
would ask the
as clear
question.
as mud.
You would
Hold
ask.
on a second, everybody.
No, I think it's pretty, in my opinion, it's pretty clear.
Let's let David
I just
have a
want to
word
say,
there.
Maybe I can
Well,
clarify.
Hold on, let's let David have a word.
Let me clarify this a little bit. So there are principal permitted uses, right? Those are designated and enumerated. And the benefit of fitting into those categories is that you then don't need authorization and site plan approval from the planning board. So put that aside now. That's not what's being asked for or represented by the owner. The owner and the determination that the planning board is appealing is saying that they fall into the category of special use, i.e. it still will ultimately, even if the owner prevails, will then still be subject to authorization and site plan approval from the planning board.
correct.
So,
That's what I was
so
gonna say.
they say they fit into that category, and specifically,
And the owner's not the applicant.
sorry, I'm using that
The owner's
interchangeably.
not the applicant.
You're right.
Yes.
You're right. I apologize. I didn't mean to add confusion. So we're just focusing on the special use category, and one of the enumerated special uses is the automotive service station, which, as we've heard, the code defines as a building or lot or part thereof devoted primarily to fuel dispensing, repair, servicing, washing, or reconditioning of motor vehicles.
Primarily.
And that definition is in Chapter 57 code
Yes.
Yes.
of fuel dispensing.
Yes,
Okay.
that definition that says fuel dispensing,
Okay.
that's the definition.
Thank you.
Well, you'll get to come up here and make your.
Yeah, we'll hear.
There's no overs,
No,
don't
no,
worry.
we'll-
Everybody gets their
we'll
time.
hear.
Everybody gets their time.
Yeah,
Yes.
we're
Heckling doesn't help.
we're trying to figure it all out. All right.
Yeah, so
I
this is where
appreciate
they feel they
your
fit.
part of the story,
The
yes.
planning board doesn't believe they fit there. And you, again, to Steve's point, you asked about site plan approval. That'll come later. They're just trying to make the case that they fit within this zoning district. Planning board does not believe this bus terminal use is allowed. And that
Understood.
it's a real change of what the intent is when it comes to automotive service station. And that we do think it's clear. We just think what muddied the waters is trying to fit a bus terminal within an automotive service station use.
Right.
Thank you.
Anybody have any
Thank you
questions?
very much.
Thanks, guys.
You guys all right? You all right?
I'm good.
Okay, appreciate it.
Thank you.
All right, we heard their side, let's hear the other side. All right, so we haven't heard from you guys in the same amount of time, 4 months it's been, so give us the rundown. How do you guys see this?
Good evening, Mr. Chair. First, I want to say welcome to your new position.
Thank you, I appreciate that.
Before you. For the record, my name is Dan Richmond with the law firm Zarian Steinmetz here on behalf of the Excellent Bus Company, and with me is Joel Mann from Brock and Mann. Initially, there are threshold issues why this appeal should not even be before your board. Your board already touched on one of them, that this was too late. It's 30 days under your code, which specifically says that an appeal shall be taken within 30 days of the action of the administrative official appealed from. Any appeal not so taken shall not be entertained by the board. And that's section A6615 of the town code. So in the first instance, we think that this appeal is too late. Moreover, I think perhaps more importantly, I think it goes to one of the issues your board is wrestling with, that the planning board doesn't have the authority to bring an appeal. The town code, chapter A64, gives the planning board certain authority, including to approve plats, to approve development of unapproved plats, etc. It does not give it the role of a supervisory over the building inspector and does not allow it to bring appeals. So I think that goes to a fundamental issue here. The code enforcement officer, the one that rightfully determined that an automotive service station, as this is allowed by special permit in the GB district where the site is located, is the chief administrative official charged with interpreting and enforcing the code. I don't think the planning board, I mean, they talked about there's got to be some process that they should be hearing. I don't think the planning board should be appealing or overseeing the building inspector in his role. That's his job. If an aggrieved applicant wants to appeal something, they're entitled to do that. But to go beyond that, I think runs into this kind of trouble. And I then want to go to the merits. Again, it's an automotive service station, which I want to read it clearly. It's defined by your code, chapter 57-3, a building or lot, part thereof devoted primarily to fuel dispensing, repairs, servicing, washing, or reconditioning motor vehicles. So they tried to say, oh, it's got to be a gas station. No, it doesn't need to be a gas station. And it doesn't need to, and even though this will have gas, that's one of the things. But again, this is a high-intensity bus use. These are buses that travel to New York City and other distances, take people from the town and the surrounding community to those locations every day. They need to be repaired regularly. They need to be refueled regularly. They need to be cleaned regularly. That's an essential function of our client. That's what they need to run a business. If they can't have that the business, it can't function. So again, the question is, I mean, they trying to say, well, we didn't dispute, there's no contest on the use. There's a clear contest on the use. They're trying to say we're just bringing the trucks there, the buses there to park, etc. No, the buses are brought there because every day, after long-distance commuting, they need to be repaired, refreshed, refueled, reconditioned, and that's the primary use. The fact that the bus drivers may park their cars there, there's no contest on their part that this is not a terminal. But again, no passengers are going to be unloaded or offloaded here. There's no parking for that. There's no like that. There's nothing on the plan that in any way indicates that. I mean, towards the end, they're referring it to, I think they're trying to be interchangeable, use bus terminal, bus depot. They somehow think helps the case, but it's not. Again, the buses need to be reconditioned. And I'd also part of that parking is an accessory use. That's allowable under the GB district regulations. Column 3, number 3, says parking is allowed. And we meet the criteria for parking, and we're entitled to make our case to the planning board to show why we have the proper amount of parking, why circulation will be safe, etc. The normal questions that a planning board concerns. That's within their lane. Again, any ambiguity they're trying to put on the definition of an automotive service station, by law, ambiguities in a municipal code are construed in favor of the property owner, i.e. our client. So they're trying to, well, it's this, it's that. I think the language is very clear. I think what we've proposed, what we've submitted, affidavit testimony from our client, we've submitted letters explaining, this is pretty clear, and this is, I think it was a no-brainer for the building inspector to recognize that this, you're repairing buses on a daily basis. It's an automotive service station. I'm happy to answer any questions you have, but I think this is a pretty simple case. I think, again, as threshold issues, this appeal should not even be heard. I think your board should make a determination that the planning board doesn't have the authority to bring appeals, and I think it should be clear that there's a statute of limitations that's imposed by your code that limits the ability to bring code when they need to be brought, and if they're brought too late. I mean, again, the law is clear throughout the state. These statutes of limitations, the short statute of limitations for land use matters are brought there because, again, it's an interest of moving applications along. But again, even if you get to the merits, I think it's an automotive, I don't understand how you can argue that a bus company that operates buses that a long distance that need to be repaired and that we have a maintenance building specifically designed for that is somehow not primarily an automotive service station, regardless of cars or these buses also need to be parked there for a time.
I wanted, go ahead.
Yeah, Joe Mann, so just to add some more details, and again, also about how the land use process and the informal meetings are working. So first of all, like attorney said, it's in the definitions where it says automobile service stations, everything that's being counted in the in that. So there will be fuel, because they use the fuel to fuel the buses there. There will be repairs, there will be servicing, washing, everything will be there. You can see the building is designed 60 feet deep to be able to take the buses in. There should be 5 bays with the offices. That's the primary use of the property, to make the service station and the offices, both are allowed in the GB district. And the accessory use will be like using whatever the parking will need to be, or overnight, or when the buses are not used. But that's, I don't see it, and I think that's what the building inspector have seen, nothing different than we have, like, let's call it the air condition repair company. They have they have an office, they have a storage, they have the material, then they have their 10 vans or 15 vans parked outside. Employees coming every morning, take a van to the site, they work there, come at night, park the van back. Is that a air conditioning company parking station that's not allowed there? No. You have the offices. No one wants to have their office separate from where they have their equipment. So they keep their equipment on the property. That's the same thing. You have the automotive service station, you have the bus, the offices that's coordinating all the buses, both are primary uses. It's a special use permit, but it's a primary use. Then they have the accessory, they also use the property to park the buses in it. Going back to and the plans are clearly showing that. The reason why I went to the informal meeting initially was more for the uncertain area as of traffic. So the DOT has a plan to redo the whole corridor. I think it's public too, so we had a fundamental question on how the planning board would like us to start working with the traffic. So before getting into too much money invested in the property, we want to know where they will like the entrance. We hired right away, we had at the meeting traffic consultant, Colliers Engineering, the big professional from here. That was the more important thing that we want to get the feeling from the board. At the first meeting, they questioned, oh, is this allowed in the zoning? On the first moment, I got a little bit, I got confused because, yes, why is it not allowed? No, a bus, they said a bus is not listed in the zoning. And I asked, why is it different than any other type of company, like I just explained, from an air conditioning company? So I told them, listen, after the meeting, we'll see you at the second meeting, let me figure that out. So there is a formal process in the town that the town did. It's a land use determination form. It's an official letter that you can fill out, can go to the building inspector, get a land use determination. It was nothing like I was trying to be sneaky or do anything, just did the right thing. I met with Dan, we filled it out, we made a narrative, because that's requested there. And I've not even met the building inspector. We just send it in, and like we followed a week or two later, we got back that yes, this is allowed by the code. So the next meeting, I put this letter up. Oh, we didn't know about it. So it was like we didn't have any official application of the planning board that we should go through. Typically, sometimes at the planning board, there comes up zoning questions. The process is that the planning board is saying, okay, we will reach out to the building inspector, we will ask about it. That was not the case here because we were not formally at the planning board. So I used that land determination and we went through the regular process. I got surprised when I've seen the appeal from the planning board. So I hope that we can solve this here and appreciate your time for that. And I will answer any questions that you have.
I appreciate you clearing up your side, and I appreciate them clearing up their side. I still have some questions, though. So we have this service station that we want to refer to it as. That's how you guys want to refer to it as, service station?
That's what the building inspector said, yes.
Is that what you guys would say as well, though? It's
so
a service
that's
station.
basically any use that I'm doing
So service station.
planning for years. Any use that you want to do, like the zoning is not making a list that every nitty-gritty use.
Sure.
You have to fit into one of that general uses. So
Sure.
Yeah.
Now, you guys didn't like the term bus depot. You're saying it's not a bus depot, it's a service.
fact, it's not.
It's not a bus
The
depot, okay.
passengers are not going to be loaded and unloaded.
So there is no passengers whatsoever ever coming in and out of here. It's
Correct. No
only
passengers.
workers, it's only drivers, only mechanics, only customers
Only
that
the
would have,
people are working for
okay.
Excellent Bus.
Sure. Are we getting the same buses every day? Are these new buses? Are these
No,
always the
they have
same
a
30
fleet.
buses? Is a fleet of buses?
They
Or
have
are
a
you
fleet
taking
of
new buses in
that
on a
they
constant?
They have two locations. They're going basically from
Back and
Brooklyn
forth.
to Monroe. They have I think they have some location there. I'm not sure the owner is there. They had one, like a service station there. They have a service station here. And
Yeah.
so the buses are
30 buses
exchanging.
going back and forth between these two sites, we'll call it.
Correct.
Service station, bus depot,
Yep.
however you guys want to argue about it.
Yep.
Okay. Does
This-
anyone have any questions referring to this?
I do. I have one question. So when you first had the informal Zoom call meeting, it was defined as a bus depot, but now we're saying it's a service station. How did we kind of shift?
I didn't define it
One
as-
second, I'm sorry. How did we kind of shift in definition? I just want to get some background as far as why that came to be.
We never shifted it.
Yeah.
Again,
So wait, I thought it was said before, I could be wrong. In the first informal Zoom call meeting with the planning board, it was identified as a bus depot. Or it was stated it was a bus
So
depot.
they asked me, is this a bus depot? Because it does meet not under the zoning. I told them, no, it's not a bus depot, but so where is it falling in the zoning? And I was clearly, it's falling under the automotive service station, but I got a little bit confused, like at the meeting, because like I said, the initial focus of my meeting was more like on the traffic. I submitted like four options on how the entrance shall be. That was the main focus. So I told them, listen, let me refocus again on that, and we'll come back. And I came back again, clearly defining it, what it is.
And it's an informal meeting. That's not
Right.
legally
Yeah.
binding. There's nothing.
No.
That was
Right.
just goodwill by both
Just
parties.
want to get
again,
some background as
the
far as
planning
definitions.
board-
Exactly.
Yeah.
Again, the way the planning board, even though when we go for the planning board process, the way they approve things, they have conditions. So we represent something, it's in the zoning, they will approve it conditioned upon that we need to make this automotive service station as the main primary use and that's the accessory use. That will be the approval.
So I agree with you guys that this is an informal meeting you had where none of that is set in stone. I will say, bringing 29 buses back and forth from two sites kind of feels like a bus depot. Now, I don't know if that term is upsetting everyone, but that's what I would have assumed a bus depot was, where you keep your buses and then you take them to the next one and then you bring them back and forth. I didn't think of it as, like a pickup spot for passengers. So I'm kind of on the side that this sounds like a bus depot, personally. Now, I'm not saying one way or the other just yet, but hearing out from both sides, am I wrong? This kind of sounds like a bus depot.
but I don't
Which is, there's no, I'm not saying that's a
I
problem.
understand. I can't even say, I don't know, it's hard to say what is the definition
Like
of bus depot,
a
what is it?
service station to me, like a service station would be your regular mechanic down the road where I can bring my car anywhere. This almost seems like a housing spot for your buses.
No,
Which,
Which also services them.
which also
Which
services.
is understandable.
If you have 30 buses, you gotta serve
You got to service them.
Let's,
nothing about the definition of auto service station that says it needs to be open to the public.
No, 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 no. I don't,
No.
like I said, this
Okay.
is not,
That's,
but I can point out a little bit more. Let's say we're not doing a service station. Just let's think out of the box. We're doing just an office building where the whole offices for Monroe Bus is sitting there. They have their offices, their meetings, their communication, their coordination, everything is there. Now, that's the primary use, that's allowed in GB. It's not even a question. Office is a principal permitted use. They have equipment. What is their equipment? Buses. Can they park the buses outside as an accessory use? Yes. The reason I didn't want to say office, because I don't have only office, and I don't want to be restricted to just office, and because in fact, we will service the buses. We'll have 5 bays. It's a building, and we're going to do that. So technically, I didn't even push that out, and we have 2 primary uses that are allowed in the GB district. It's office and automobile service station, and everything else is an accessory. So,
I have a question, I'm sorry, it's for council though. So we have a definition in chapter 57 of what an auto repair shop is. Do we have a definition of what a bus depot is?
Closest, so I dug through the code looking for such a definition. There is not one. One thing that has not been raised, though, the code does recognize that there is something known as a bus depot. Section 57-13F doesn't define it, but it distinguishes a, quote, bus depot from a, quote, bus passenger waiting shelter. So, no, there's not a formal definition, but the code recognizes that there is such a thing as a bus depot. And I would just add, just as a general principle of statutory interpretation, you know, words are supposed to have their regularly understood meaning.
When you think of any bus depot in town, right, what do you think of?
bus garage on Mine Road.
How about the bus depot, the Shoreline bus depot across the pond?
I don't consider it a bus depot. A bus station. There are no buses there, that bus stop. That's how I think about that. A bus depot, I would think about the bus garage on Mine Road. That's what I would.
That's what I would envision as well.
Do we have any bus depots already in the town of Monroe that we could see how those are zoned?
good question.
Good question. I'm not sure even a bus depot is not allowed. It's just not listed, but
I believe that their bus depot is just into the village. I don't
That's the
know.
only thing I know of where they're actually
it's maybe it's
Storing
probably
buses and
it's
repairing
probably an
buses and
accessory to the school.
fuel buses,
So,
all the things we're talking about today. That's the only place I know of in Monroe. I could be wrong. It's the only place I know of, though.
All right, one last time to beat the dead horse. What's the day-to-day that's going on there? What's the plan? What's your plan for the building?
so there is a building.
Mhm.
There's people coming in every morning. That they are dispatchers,
Workers.
workers, mechanics, accountants, bookkeepers, the owner, everyone comes in that building, works there. So a portion of the building is the offices, a portion of the building is the mechanics. Every bus, before it starts the route, goes into make sure, I don't know if it's being done the night before or whatever, that day, there's a fuel station there that all the buses are taking their fuel. The building has servicing, refreshing. The driver comes in, parks his car, picks up the bus, takes it, comes back later when it doesn't need it, tops it off, gets in to make sure that it gets into the garage to be cleaned, because that needs to happen. So everything goes together with the building.
Sure.
So
29 buses for the 29 spots,
I
29
just did the
drivers.
max. Actually, they don't need 29 buses.
Okay.
They're not using
25, whatever we want to call it, but each spot will have a driver that comes in.
Can you come up, please?
Oh, yeah.
Can you come up?
My name is Getzel Gelb, and I'm the president of Excellent Bus Service. We own 29 coaches. The only reason why we made it 29 coaches, there's certain times of the year that we bring in, basically when we have a big move. All the 29 coaches will show up at that location. But most of the time, we have about between 12 to 15 to 16 coaches a day, per day runs out of this location. But it's 50-50 on the two locations that we have.
We appreciate you guys clearing that up. So if you have anything else you want to bring to the table, anything new from, you guys have any more questions?
No.
I have one more question for council. Council, in the absence of a definition in the local zoning code, in this case, obviously, bus depot, would it revert to the New York State Municipal Code definitions? Is that a fair statement?
Look to that, and if I was asked to interpret something.
Because just on a quick lookup, it says bus depot definition according to New York State municipal codes, and the state's core definitions is standard local municipal codes across New York State define a bus depot as a designated property, lot, or series of buildings used for the storage, parking, dispatching, and routine maintenance or washing of buses.
I would give certain.
Thank you.
It still falls under automotive service station too. It's just not listed. It doesn't say in the code that you're not allowed to do a bus depot, just to make it clear. So,
That's what we're here to figure out. We appreciate everything. If you guys have anything else,
thank you.
Thank you.
no problem.
Thank you.
Thank you very much.
Now, this is a public hearing, so we do have time for the public to stand up and speak. I see you out there, sir. I'm just going to, is that okay if I give Bonnie another minute, council? Just come sit up at the microphone if you can.
It might be, it might be prudent to hear you first in case this member of the public might have a comment in regards to that.
So the town code, I don't understand why it would be even suggested that we don't have a right to appeal a determination of the building inspector. First of all, the Monroe Code, Article 15, says, general grant of power, the Board of Appeals shall perform all the duties and have all the powers as described by the town law. That's meaning New York State town law. So your power flows from New York State town law. New York State town law says that you can hear appeals from any order, requirement, decision, interpretation, or determination made by the administrative official charged with the enforcement of any ordinance or local law, meaning the zoning. Such appeal may be taken by any person aggrieved or by any officer, department, board, or bureau of the town. We are a board of the town. New York State town law grants us the authority to appeal the building inspector's determination to the ZBA, and the zoning of the town says that you can hear those appeals, number one. Number two, New York State town law.
We understand this. You're here.
Yeah.
We're hearing it. So this
Right,
is,
no, but the
you're just I understand.
yeah, they're
but
saying that we don't
everyone
have
can
a
say
right.
whatever they want. It's our job to go through that.
Understood.
That's why we're listening to you.
Thank you, I appreciate
So-
that. And then I just want to add that New York State town law says an appeal shall be taken within 60 days after the filing of any order, requirement, decision, interpretation, or determination of the administrative official. So New York State town law is 60 days. So I just wanted to add that to the facts. And then-
We're hearing it.
Thank you.
You're
Thank
here.
you.
You're here. Thank you.
Thank you. Yes, just to be fair, allow him to respond. Thank you for coming up and speaking your piece again. One last time. It's only fair. It's only fair.
I don't get you heard, and I appreciate your time. Just, regardless, I appreciate your board's authority, who your board is entitled to hear, but the town board of the town of Monroe, for whatever reason, did not give the planning board the authority to bring appeals. I don't think the town board wanted the planning board as a supervisory agent over the building inspector. One, two, the town code says 30 days. Thank you.
Are you speaking on behalf of the town? I'm not really sure.
Yeah.
I don't, well, yeah, kind of. I mean, the town supervisor's
Town
sitting next to you,
supervisor is
so I'm
They're
not-
nodding with you.
I'm just not
Is-
really sure.
Yeah, well,
The town supervisor seems to be nodding in agreement of everything you're saying. That's why.
Thanks, Steve. I actually am just nodding along because you guys have been giving the applicants quite a lot of time to speak, and there are people in the audience who are, as I directed Alyssa, waiting, and they are all entitled to their 5 minutes.
Yeah, no, we don't have a time limit here. You
So you
5
do
minutes
also have
for
an obligation to hear
public hearing.
both parties equally, and which you've essentially done. But I'm nodding along out, he's not representational in town. You can sit back down.
Okay, I was just making
So
sure.
as attorneys come up and assert on behalf of the town board, I'm just having a hard time as a spectator. So I'll speak to the fact that he's completely wrong, that the planning board has no authority to come before you. That's exactly right, Chip's exactly right, to hear this case.
Yeah.
Town law, New York State town law does imbue that authority, and just in absence of such in the town code does not restrict the planning board from coming before you. However, it's the opposite for the second case, which is what I thought he was originally saying, which is why I was nodding no for his first statement and yes for his second statement, because how it works is, as you know, federal, state, federal does the broadest strokes of the Constitution, life, liberty, pursuit of happiness. New York State has additional prohibitions as opposed to Texas, and then it gets down to the local level. So anything that the town board decides, we're imbued with a certain authority. However, we're the last, smallest form of government, so we put the tightest restrictor on, and our restrictor is that of 30 days. However, it has been mentioned that it is in the code that upon good faith, good cause shown, that one could extend that. I would be very wary about that good cause shown, because it links to, what is it, A15 versus A18, the prohibitions in the code, David, for good cause, and then it says that it can, A18 says the zoning board through good cause shown can alter, 15, 16, 17, and it doesn't actually state whether you can amend those timelines or whether you can amend, it's referring to filing with the chair, filing with another, like changing the process. I don't believe that the 30-day prohibition is supposed to be altered in good cause, because there's no definition of what good cause even is, so you do have to be careful, but that's up to ultimately your legal counsel and your board's discretion. So I would just, as a town board member who is responsible for overseeing and understanding, and who is responsible as well for the town employee in part, and oversees all of you, I would just, I'm just here to remind that that is what the intention is from the town boards and the, actually the town attorney. 60 days is the state code, 60 days is New York State town law, imbues that authority, 30 days is the final restrictor placed on previous prior administrations, and then there's confusing and muddled language of good cause.
So 60 days is acceptable in New York State, 30 days is acceptable on a local level.
That is what the prohibition, there's an additional restriction that it was supposed to be 30 days, and that there was banter about in case law, in certain circumstances being from when they found out or when there was time of notice. That is not applicable in our law. So case law can be argued for different towns, different villages. We all have different home rule enacted policies, procedures, and local law. So you have to go by the town of Monroe's local law, informed, yes, by New York State law. And in one case, the absence of reference to the planning board does not prohibit the planning board from being heard in front of the zoning board, not at all. But in another case, it is explicitly changed, and that's the difference. So that's what I wanted to make clear. And no, I'm just talking with everyone in the audience because we're all municipal nerds, so thanks, guys.
Thank you.
Oh, actually, one more thing.
Time's up.
I know, right? So for automotive service station, I am interested in the bus depot. I agree, it does sound bus depot, and it's only mentioned in the one prohibitive section, and it's actually about a bus shelter not allowing, mention of a bus shelter shall not be confused with a bus depot, right? So we're not allowing, in residential areas, we allow bus shelters, right? Even in our R1 for the good faith purposes of public transportation. We want our passengers, our constituents to get to where they need to go and have bus shelter allowing everybody, transit around the town. However, that should not be mistaken for a bus depot. So that's the only reference of bus depot. And I do tend to err just on the legality side and a litigious side as a recommendation from the town board and the town attorney, as well, is that an automotive service station is, again, we were saying fuel, service, conditioning, or, and then another clause, it is not primarily used as a fueling station. The best example of that in our code is the fact that a gasoline fueling station is actually a separate additional definition under the zoning code. So it does not at all, the word or in legal language services that it's all equal under the clause statement under the automotive service station, and additionally, the gasoline section is a different and separate primary use is fueling section of the zoning code. So I would say that, and the fact that there is an absence of bus depot in a litigious world, you realize that that implies that the entire town of Monroe prohibits any sort of bus depot. And if our only argument here is that it's because it's not included in the GB, it means very likely that it was left out of the town zoning definitions altogether. And who's to say that that was an intentional or an accidental move if the town code further defines bus depot only under the bus shelter? So then you're restricting, rights constitutionally, you could argue, that how can we have this or not, right? So how can the town of Monroe address a bus depot versus an automotive fueling station? And at this point, the building inspector's determination, it's meaningful, right? But it's also meaningful that, I think the zoning board really just, you guys grant variances, you guys seem like the best board to determine this. I don't really want this footed back to the town board. I know that was brought up.
No.
Determination.
No, we got this one.
Yes, this is like an interpretation that should be in front of the zoning board, but it should be seen that we don't have that definition at all. So was this left out of the code, period? I think there's code rewrites, notes for code rewrites all in this case to further define this process. But basically, functionally, is it going to be that much more impactful even if you call it a bus depot and claim that it's prohibited? As one of the applicants said, is it going to be that much more impactful as this use versus what you are perceiving as a traditional automotive service station? And in your purview as a zoning board of appeals and granting variances, you had to take a broader look of what legal result is going to happen here, because we have the opportunity as the town to request and negotiate with these decisions that we're making to request more land be preserved, that the town be given a conservation easement, that maybe the home not be knocked down. And right now that applicant is willing to do that, whereas if there's a decision made that goes against what they believe that they're lawfully entitled to and may be lawfully entitled to, which is up to the determination of yourselves and then a judge, because they can always appeal the town's decision, we would then lose that advantage. So that's all I want to say. Thank you.
All right. Is there anybody out there in the public who would like to speak? Sir, come on up. If you could just come to that podium, right? Thank you.
To make sure the mic.
Also,
it's
state your name, state your name and address so that for the
Mike
record.
Andrizzi from Monroe, New York, town of Monroe.
Thank you.
Sorry I was late. I thought it was 7. Apologize for being
Right.
late. And I'm a little confused on the location, if you could just bear with me. It's not listed on the website, it's not listed on the agenda, and the TV monitors aren't on. So there's other people in the audience as well as myself. So I know it's late in the thing, but if you could tell us the location?
The O&R Lakes, You know where the O and R lakes are?
Yes,
So you
by
know,
by O&R, by the medical, by the
right,
tile
so you
place.
know where they do the jet skiing?
Yes, yeah, yeah.
So that house that looks like kind of like a chalet, a mountain
Okay.
house, that's the
That's
property.
the location.
Okay.
That's it, yeah, if you want.
It's actually 485,
Yeah.
485 Route 208 Monroe.
So the reason why I bring that up is it residential or commercial? Such as where the school bus location is kind of like in a residential area. So that's why I wanted to know. Something that nobody brought up, why I don't know, what's the hours of operation? So to me, it's clearly 24/7. And I think that's a big concern of the location. As they said, buses are coming and going. As they said that they have to be repaired. The offices might not be open 24/7, but the hours of operation. And that to me is even more a reason that it's clearly a bus depot.
So the hours of operation that are listed, not to cut you off, just to give you information here. Sunday through Thursday from 6 a.m. to midnight, and then Fridays from 6 a.m. to 5 p.m.
Well, so what was the last one?
Friday from 6 a.m. to 5 p.m. So nothing will be going on after midnight.
It's still midnight. It's
Yeah.
changing the,
Sure, no.
more and more we're turning into a city where we're going from residential and a small community. And I understand we're growing and whatnot. I just feel, and you know, you always hear push, 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 ask for the most, and then whatever they give you. There's always the saying about do what you want and then ask for forgiveness afterwards to try to get the maximum. So you really have to keep in mind, they keep saying 29. 29 is the magic number. It gives them a lot more room to expand and grow. That's the number I would keep in mind, not the 12 to 15. Again, I believe it's clearly a bus depot, and I just feel there's different locations for it. I'm not saying it's not the right location, but they clearly are trying to, just me sitting here, their wording keeps changing. They're just trying to figure out whatever they have to say to get it into a certain classification or category to try to get it approved. The other thing that I'm surprised, I know things changed over the years. I did go to a lot of meetings. I guess I'm going to have to start going back to them and start bringing more people to these meetings. I'm surprised that the town supervisor, I know maybe because it's a public meeting, but I'm surprised that the person showing up and pushing, this is just my interpretation from being here a couple of minutes. Normally, you should be doing your job. In my opinion, the planning board should be doing their job, and that's why you have a town attorney. You're supposed to rely on the town attorney, not a town supervisor. You know, in the cheering section, yes, no, nodding a head constantly. Again, I'm not here to make waves or trouble. I just feel that you shouldn't be influenced. She should not be influenced. It shouldn't be a biased decision. It should be a neutral, non-biased. And again, it's a public meeting, but that's why you have a town attorney if you have questions to ask him, not to keep, back and forth coming up, no, 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 yes, yes, yes. That's it.
Make no mistake, we are doing our job.
I know.
No, I'm just going to, I want to clear it up because if you were come to the meetings, you would see how this board operates and how we do our job.
I'm not saying
Well,
the board.
I'm just letting you know.
Just to clear, I'm not disputing the board. I'm not knocking the board, just the opposite.
Well.
I just feel that somebody should not be, the way I just started, again, public meeting, I could say, okay, yeah, people have a right to be here. And then, well, I'm here as a public, but I'm not here as a public. I'm the town supervisor, but I'm not the town supervisor. I just found that I've never seen, with all the public meetings I've gone, I've never seen that before.
Appreciate your opinion, and we hope to see you next month.
Yes, thank you.
Thank you very much, sir.
Very much.
Someone else? Come on up. Just state your name when you get up there and just make sure to talk into the microphone.
Good evening. R.A. Lazarus from Ski Delight, one of the owners of the neighboring and abutting properties. the water ski lakes that you mentioned. As you all well know, the lakes are used for recreational purposes, families, abundance of wildlife, kayaking, canoeing, fishing, etc. There's currently a single-family home, which is like a mountain chalet, as you know. And just from our perspective, just to reiterate for the record, just because I know it's been raised before, our preference would obviously be to object to any use as a bus depot or that sort of use. I guess that's it.
Thanks.
Thank you, sir.
Is there anybody else out in the crowd there that would like to say anything? Don't be shy. If you got something, yeah, come on up.
Come on up, sir.
Thank you for coming out tonight. Just state your name and just speak right to the microphone. Thank you.
Monroe, New York.
What's the name?
Mark Lundy.
Mark Lundy.
You actually have to speak into the mic. I know I sound like I'm nagging, but.
Yeah, sorry about that. You guys do a great job,
Thank you.
okay?
sir.
I think what he was harping more on was that I don't think that our town supervisor should be lobbying for them or defending them or trying to get you to understand I think that's the job for our town attorney and for all you guys to make your decisions. As far as the hours of operation, it's a big thing. I mean, we did live in a quiet little town. I live next to the 72-acre project that's going on Round Lake. And I personally have EPA and DEC investigations going on now for environmental impact. Come to a lot of, this is time for another meeting, but I do agree that this 24 hours of these hours, it's gonna go over the hours. It's not gonna be blow a whistle at midnight. And it's a residential area. And like you said, that lake is used for water skiing. Everybody fishes there, and to be having trucks getting fueled up, oil dripping out of these vehicles, going into the groundwater, it's gonna go into the lake. You gotta look at the long-term impact of this, plus the noise, the traffic is horrible as it is. You guys know that. I don't even go down 208 anymore. I dike the long way through Chester. But I think that's something to really consider. We don't have the infrastructure, we don't have the roads, we just don't have it for this kind of expansion. And this kind of, it's detrimental to the community, I think. It's not in an area where it should be, especially right there. So, just something to think about.
Really appreciate the input. Thank you for coming out.
Thank you very much.
Is there anybody else out there? Come on over.
I just want to put on the record that I am absolutely here tonight as the town supervisor. That's why I'm seated and presenting, not standing at the dais. I have done this for other meetings in front of other boards, including the planning board. I'm usually invited or asked to speak or indicating that I'm going to speak. I'd like to take it a step back and describe why I'm here specifically, why I go to specific meetings to put in my input. In this case, as Chip and basically everyone has reiterated, this is a very unique situation where the building inspector, a full-time town employee, a department head who's directly under me as the town supervisor, who I'm responsible for.
It's actually not that unique.
Excuse me?
It's not that unique.
For the town of Monroe.
This has happened several times.
Well,
It has
I've just
absolutely
observed
happened
what
several
you guys,
times.
the comments that you've
This is
made,
not new.
that you've been put in an unfortunate position where the
That's
planning
true,
board
but it's not
chairwoman.
unique.
I appreciate it. Continue. All right.
Okay. Again, I'm just responding to the constant complaints that I have received from the chair of the zoning board. Chip, can you say a yes?
This is true.
This is
Both
true.
Zach and
I have received the constant complaints from the chair of the zoning board.
About putting in the middle.
About being put in the middle.
Oh, yeah.
About the distress. I have received the legal bills from Adam Rod's firm because one of our branches of our town is suing another branch of our town and being overheard by a third branch of our town. Whether it's appropriate, I agree. I believe that everyone is following their judicial rights. However, we've also gone over our legal budget due to planning, and there was no formal resolution by this administration or the former administration in allowing or supporting this appeal. It's a completely unique situation in several behind-the-scenes ways. We allowed that to go on. We will be footing the bill. We have gone over budget. And every single one of y'all have come to my office and talked to me about this. And again, he is the zoning board attorney. This is David Chen. You all know that. For the audience, he is the zoning board attorney. He is a separate and an independent attorney and firm than the town attorney. The town attorney and our office had to review this to see if we would even allow or continue to pay for legal representation on behalf of the planning board, given the timing and the cutoff deadlines, correct? We have to, as the town supervisor's office and the budget officer, CPFO, make these decisions, and whether the administration, the new administration, wants to continue this funding, right? So she has legal representation, and we are continuing to fund that. That is just basically what I wanted to put on the record, that I am completely in the middle of this as well, and I'm going to have to be in the middle of a lawsuit, because it is not going to be necessarily David Chen or the zoning board attorney who defends us in court. It will be either an insurance represented attorney that we fund, or an alternate, might even be the town attorney's firm, so who do take care of our court cases. Yes, we make those legal decisions, that's completely my right, and the interpretation of the code. If all of our departments are weighing in tonight, I don't see why I shouldn't be able to weigh in, and absolutely I'm not endorsing the applicant or the planning board or the zoning board. I've had, as you saw, my distinct and independent opinion about the interpretation of the law, where I even agreed this may be considered a bus depot, but you have to take it a step further and get into where we are thinking of how much is this going to cost the town versus the impact that it may have to residents, and what is a legal argument going to look when they take it to a judge to
If I can just stop
potentially
you,
appeal
if I can just tell
your
you one thing,
decision.
though, that's not within our jurisdiction. Our jurisdiction is solely to make a determination based upon the definitions brought for us as bus depot, auto repair shop. We don't take into account, as the Zoning Board of Appeals, and I'm sure my members can attest to this, we don't take into account of legal costs, of conservation,
No, I said that's
things
my
of that
office.
nature.
That's why
Right.
I'm here
That's
to
not
provide
our-
that to the perspective. I'm at the public hearing providing that perspective
Right.
from the town supervisor's office in my official capacity. I am not here as a member of the public, and I put it on the record. Thank you so much.
Right, but that's not within our jurisdiction as a board.
That's why I'm here. Thank you, Steve.
Thank you.
But just to clarify and to go on the supervisor's comments, I've spoken to every board member here about us being placed in the middle, and I spoke with Maureen, the supervisor, about it, just like I spoke with the last supervisor about it, and the point I was trying to bring to Bonnie, the planning board chairman, if we're going to be doing these pre-qualification meetings, whatever you want to call it, fact-finding, there needs to be, for the sake of the town, that the building inspector and the planning board chairman work together instead of kind of butting heads. And those were my words to this supervisor and the last supervisor and every member of this board at one time or another.
Right.
So
It seems that we're getting land use determinations or whatever it may be made by the building inspector without consultation of the planning board, and then it ends up coming in front of us for clarification or
Right.
determination.
And who-
In my recent past recollection, I think this is the fourth time that it's come across our board
Yes.
here.
And they
And,
do.
and it seems to be a breakdown of communication. Obviously, if the planning board wasn't even notified about a determination that was made, I have to say it comes back on the building department.
We have a communication issue going on here, because this has occurred 4 times, like Steve said. And personally, I don't have a problem with it. If they come to us and they say, we need help, that's what we're here for. But it does make a bit of a mess. And I think that it could be fixed with a little bit better communication between all of the channels here. We have the zoning, we have planning, we have the town board, we have the building inspector. I think we just have to get on the same page. I don't think it's that hard. I think we can do it.
and it does get costly.
It does. I mean, if we keep doing it
It leads
this
to
way,
lawsuits.
we just keep, and I know town supervisor just said it's getting costly, but again, the town supervisor and us need to come together to figure out a way to prevent it from getting costly. We have to get ahead of this instead of staying behind it. And I agree, everybody's going to have an opinion on this, but I think the best thing we can do is work together. Now, does anybody else have anything to say about this matter? Bonnie, I'm reluctant to let you back up again.
It's just about process.
All right.
So for what it's worth, I don't even know that it's ZBA related. But because of what has occurred, we have stopped having these advisory committee meetings because we don't want to get in this same situation again.
I think those meetings are good, though. I think that's a mistake.
but-
That's a mistake, right? Because
But we need a process so that this doesn't happen, because this is what happens. And I will tell you that when something is on the planning board agenda, we ask our attorney to consult with the building inspector. We ask our engineer to consult with the building inspector when we have questions as to a use. So we are providing that communication as a planning board to the building inspector. We were shocked to find out that a determination was made without any knowledge at all about this. And part of the problem is because there wasn't actually a formal application at that point. Had there been an application, we would have been in the loop because this would have been in front of our board. But this all stems from a conceptual use for which there's nothing official. So I agree.
So
We need to
I
work
think,
on
I think it's
process.
I think it's a mistake to stop those pre-meetings. I also am not going to sit here and play God and say that it takes two.
Yes.
It takes two, right? So I'm not going to say it's the building inspector's fault or your fault. I don't know whose fault it is. All I know is this
I
is
agree
this
that it
kind
can
of
be better.
stuff that just clogs up a system that gets costly, and it's happening more often than not.
I agree that
And a lot-
the process can be better. I would also say that this is not some exception that other towns don't experience. It's just when you have differences of opinion, the method of determining how to come to some outcome is to go to the ZBA, and that's what you're here for. So
And if it's commonplace, then, I don't really care about another town. And I just think if the two people can talk,
So maybe what it comes
something
down
would come
to
from
is
it.
the town needs to implement some type of policy with forced communication
Well,
between the
that's-
different departments.
That's what we had discussed again
should it
in
come to
20
that?
in 2025.
Unfortunately, yeah.
Yeah,
Because this is the
So
fourth
I
time
can't-
here.
come to that.
We did make the request that we have to figure something out and to put some policy out.
Yeah,
Here we
that's-
are, and we need to move forward and come up with some kind of process.
Because ultimately, you know who the losers are here? The taxpayers.
Yeah, agreed,
And that's unfortunate.
agreed.
And by you not knowing, and if they circumvented the system and the building inspector gave him the okay, in their mind, they didn't feel, they weren't at that step yet. So I can't even blame them. Right? They're just a product of a failed system.
I don't entirely agree with
That's my opinion. They
I
are a
appreciate
product
that.
because
I
the two of
respectfully
you
disagree.
can't speak.
I respectfully
Right?
disagree.
And that's not a secret. The two of you can't speak, so that's where we're at.
I would only add that as far as representation, and again, I don't know if the town board was requested, but we were given authorization to utilize Mr. Rod's firm to represent us. Whether that's a supervisor decision or budget officer decision or town board decision, I do not know.
Not a zoning board
It's not-
decision.
not our-
It's
not our-
not a
not
zoning
our
board
concern.
decision.
Definitely not our
And I'll be
concern.
honest with you guys, I love
Yes.
hearing all of these complaints
No.
and concerns, but
Yeah.
we're here for zoning. We can't air all the dirty laundry. If we have to have conversations about procedures and work on this and fine tune it, we should all work together on
We
this,
should have a little committee.
But this is
Agreed.
just zoning here tonight.
Agreed.
But I do appreciate everybody coming out and giving their 2 cents on this because it's an issue.
And we appreciate you listening to us, so thank you
Thank
very
you.
much.
Thank you.
If anyone else has anything else to say? 30 seconds.
This
You
is
got
it.
30
This is it.
seconds. 30 seconds, that's it. We're going off
I
the
just want
rails.
to put on the record that Ben Maldonado had the complete and utter right to make a land use determination. It's a form on the town board website. and it is an independent authority that is not simply a referral from the planning board. I just want to defend him, that is his statutory right as building inspector. We wouldn't even be here tonight if that weren't the case. So I agree with everyone that it's a communication issue. He's not mandated to send her a notice, but there needs to be a town policy as stated that corrects this going forward, because
We
it's
just gotta-
expensive.
Yeah, it's become an expensive issue,
I
and
don't
it's
like
been,
when you all fight.
like we said, this is like the fourth time it's happened just to this board. So just let's get ahead of it instead of being behind it consistently. A couple more seconds here.
I may add shortly again, and I also didn't want to be in that position. I'm working with all levels of governments in the town, the building inspector, planning board. It's not my intention to fight with anyone. It's and maybe like he said, the informal meeting should continue. And I think they didn't have the building inspector at that meeting. We should add the building inspector to that meeting too. But again, there are probably a lot of
fine-tuning that needs to be done.
Fine-tuning things, and again, I have nothing personal against anyone. Just working for my client, trying to get this job through.
We have
Thank you.
nothing personal against you either. We appreciate it.
Everyone's.
All right.
Thank you very much.
Thank you.
Thank you.
All right. We're going to keep this public hearing open. That's my intent tonight. There won't be a vote tonight. Is that all right with everyone?
Yeah, absolutely. So I'll make that motion then.
I'm going to motion to keep this public hearing open.
Then I'll second that.
Thank you, Steve. All right. All those in favor?
Aye.
Aye.
Aye. Thanks, guys. All right, on to the next one. Joel Branch, 190 Cromwell Hill Road. I don't see Joel here tonight, though, so I'm nervous about him. Alyssa, did Joel...
you sent an email today about somebody withdrew for tonight? Was that Joel Branch? Oh, okay.
Ludlam Road was canceled. I got your correct.
And I put it in the packet.
Is anyone out here representing Joel Branch? I don't think so. No, you've had enough tonight.
Is it Branch or Brock?
Brock. Oh, Brock. Sorry. Terrible.
No,
Brock.
let me check him.
Yeah, I botched my first one.
I remember the email.
I'll reach out to Joel.
I call him now.
We're not, if he's not here, but I will reach out to Joel. Thank you. I appreciate everyone tonight. Whew. First meeting went off the rails a little bit here.
You're losing your grip there.
I'm losing my grip already.
It's down to 7 minutes.
Sometimes.
I'm learning. Okay, all right. We have no Joel Branch tonight. He's apparently not here. So we will have one last discussion tonight, and that's about the new projects at 150 Valley View Ave, Francisco Martinez Garcia.
Was that's not you? You stood up right when he said it. You stood up.
Because he's not here either.
And Ludlam's not here tonight?
You want to speak for him?
All right. So that seems like 3 no-shows here. Does that sound about right, Alyssa?
That's unusual.
Is it something we said?
It's my first night, no one wanted to show up, so this is like...
Alyssa, what's the next date of our ZBA meeting
It's like
for the
getting
public
stood
hearing
up
to
for
be
prom.
continued?
Just not right.
It's going to be August what?
All right. Well, if we have no new projects, no one's out here to speak for 135 Ludlam or 150 Valley View Ave, then that brings us to the end of the meeting, unless anyone has anything else to say. Yeah, we'll bring you that map. We'll bring that out to you. All right, then I would motion to adjourn the meeting.
You can have it.
I'll give him a copy of mine.
Yeah, you can have it.
I have it on my computer.
I'll second
We'll
that
run you
motion.
one
Ted.
over. Thank you.
I'll second that motion.
Aye.
Aye.